Welcome back to Ben's Bench. I've been on a bit of a hiatus lately for personal reasons, but I'm back, and today I want to talk about non-trial dispositions. I'll start in the civil context. The most well-known of the non-trial dispositions in civil world is the settlement. The typical structure of a settlement is where the plaintiff sues the defendant, and then the defendant makes an offer to the plaintiff for an amount usually less than what they've sued for, but that will dispose of the case. The plaintiff's incentive is that they get that lump sum of money guaranteed, and they get it right away instead of going through all of the time of litigation. The settlement has some advantages to both sides. It disposes of the case instantaneously, it guarantees an outcome, it often avoids publicity, and the settlement contract can have terms in it, and most of the time those terms do tend to favor the defendant, such as a non-disclosure agreement that the plaintiff won't talk about the terms of the settlement. And most of the time, if not always, the settlement agreement says that the defendant does not take responsibility for whatever the plaintiff is suing for. With that said, you might be wondering, why offer a settlement if the defendant isn't actually liable? Well, there are a few reasons. Number one, litigation is time-consuming and expensive, so it gets rid of the case. Somebody might sit down and do the numbers and say, this case is going to cost us $500,000 in litigation costs. Those are going to be sunk no matter what. Defending a lawsuit will cost that much money. So the defendant offers $400,000 as a settlement. They pay it right away, and they pay less than what it would cost to litigate the case. And of course, if they end up losing, they have to pay the penalty of the lawsuit in addition to what they've already spent litigating. So the settlement gets it out of the way and guarantees the amount of money that they're going to pay. The settlement also has some advantages for the plaintiff. Their lawyer might be working on what's called a contingency basis. Oftentimes personal injury lawyers do this, as well as lawyers who represent clients in employment discrimination. We see those commercials for personal injury lawyers that say, if you don't get paid, we don't get paid. That's a contingency fee. They take a cut of the plaintiff's recovery, and if the plaintiff's recovery is zero, then the plaintiff doesn't get anything, but they don't have to pay the lawyer either. Now, most of the time, that contingency fee is going to be a higher percentage if the case has to go through trial or appeal. The percentage that the lawyer takes is going to be the lowest if it's done through settlement, because the lawyer will have done the least work. If they have to prepare for and then conduct a full trial, they're going to take a higher percentage of the recovery. And if they have to appeal it to a higher court, they're going to take even more, because all of that is more work. So the plaintiff might want to take that settlement because that's the point where the lawyer is going to get the smallest percentage of the cut. Now, sometimes the parties can work out a settlement on their own. Other times, they have to do what is called mediation. This is where they work out a settlement, but instead of just going back and forth themselves, they actually sit down with a neutral third party who is a mediator, who helps them figure out what would be the best outcome for both sides. The mediator is neutral and does not work for or favor either side. They are just there to assist the parties in finding something that will work for them. And if successful, mediation results in a settlement. It's just a settlement that has been worked out through mediation instead of directly between the parties. The third type of non-trial disposition in civil cases is arbitration. This is like court, except instead of a judge who is appointed or elected, depending on the jurisdiction, it's an arbitrator who is paid by the parties to listen to the case, listen to their evidence, and then make a decision. Like the mediator, the arbitrator does not favor or work for either side, but unlike the mediator, the arbitrator actually makes a decision and issues an order. So it's like a settlement in that the parties agree to abide by what the arbitrator says, but it's also like a trial in that there is a decision maker who presides. One advantage of arbitration is that, unlike a court case, the proceedings can be private. They're not a matter of public record, so they can be confidential. This is good for parties who want to avoid publicity. Arbitration awards are also non-appealable. In the court system, when a party loses, or sometimes even when a party wins but not to their satisfaction, they can appeal to a higher court for a different ruling. Arbitration awards are final. Arbitration is actually what TV court shows are based on. The two parties have agreed to present their case to the arbitrator on the show, who will issue a decision, and that decision is final between them. And the incentive on court shows, if you watch the credits, is that the parties are paid out of the show's production fund. So the defendants, if they lose, don't actually have to pay anything. The show budget pays the award. And of course, the incentive for the plaintiff is that if they win, they're guaranteed to get paid. But those court shows are not actually court, because the people who preside are not appointed or elected judges, though many times they have been before. At the time of presiding over the matter, they're not judges paid out of public funds, they are arbitrators paid for by a show's production budget. There is one small subset of arbitration that I'll touch on briefly, called baseball arbitration, or sometimes called pendulum arbitration, and this is just where two options are presented to the arbitrator. Evidence or arguments are presented for each option, and then they just pick whichever one they feel is better favored or better argued for. So instead of awarding some amount of money based on all the facts, they either pick option A or option B. Many employers have provisions in their contracts with their employees that any disputes will be handled through arbitration instead of going to court. The advantages that I've just discussed are why the employer wants that. Can't be appealed, can be confidential. There's a lot of incentive for the employer to require arbitration rather than going to court. Another thing that they can include is no mass arbitration. The claims have to be arbitrated one-on-one. So unlike the class action lawsuit, which can aggregate many, many people's claims into one case, an arbitration agreement can forbid class arbitration and require each individual claim to be submitted to an arbitrator. And one advantage to all three of the civil alternatives to trial is that they are fast. A full-blown trial requires a ton of steps. There's a complaint, a response, sometimes a counterclaim in the response. Then there's discovery and a bunch of things that I won't bore you with. But when it comes to arbitration or mediation or a settlement, it can be done right away, instead of taking years to go through a full-blown trial and then possibly an appeal. And of course, the fact that they take less time is going to mean that they cost less money. So when you read in the newspaper or online or wherever you get your news that such and such a company settled its claims, don't automatically assume that it's because they were liable for something. They may have simply settled to get rid of the lawsuit and avoid litigation costs by just agreeing to pay less than what their litigation costs would have been in the first place. Now let's move on to alternatives to trial in the criminal context. The best known is the plea, but I'm actually going to save that for later. First, I want to talk a little bit about initiatives that are popping up all over the country, diversion programs. Sometimes, low-level misdemeanors, particularly victimless crimes like drug possession, don't necessarily need the involvement of the criminal justice system. Instead, the person might actually need some help. So a diversion program basically holds the possibility of that criminal case over the person's head, but gives them an alternative, such as going to drug treatment. And if they go and complete the course of treatment and maybe meet other conditions, their case will be withdrawn, so they won't have a criminal conviction against them. And then it's easier to come back from that addiction. The same is true in many places of simple prostitution. Someone who is practicing prostitution might be extremely poor, might be the victim of a violent pimp, might have drug addiction, and maybe the criminal justice system isn't really the right place for them to get the help that they need to address those underlying concerns. So diversionary programs allow people to address the problems that are leading them to this conduct that is definitely detrimental, but maybe doesn't necessarily warrant a criminal conviction. And then, of course, if they are successful in their rehabilitation or getting out of whatever situation they might be in, their case gets dropped so they don't have a conviction. But if they're not, and they fail to follow through, the case is still looming, and it can go to trial, and they can be found guilty. So there's, again, an incentive there. Now, obviously, these diversion programs are not going to be offered in felony cases. They're not going to take someone who is accused of murdering his wife, for example, and say, just go to anger management and we'll drop your case. No, that's not what diversion is for. But there's one type of non-trial disposition that's common through all types of crimes, and that is the plea. And there are two types of pleas. One is called the open plea, where the person essentially admits guilt, they waive their right to a trial, and then the judge imposes a sentence. The motivations for doing this might include the case being an absolute slam dunk and no way they're going to get acquitted, or maybe it would be highly publicized, or maybe it would take a really long time and be expensive, and the defendant doesn't want to go through all that. So they just admit guilt and say that they did what they're being accused of doing, and then the judge decides what the appropriate sentence would be. The second type of plea is the plea offer. This is where the prosecution attempts to make a deal with the defendant. Sometimes the prosecution will allow the defendant to admit guilt to maybe a lower level offense, especially if they're charged with multiple things. So, for example, if you have robbery and theft charged, they might give the defendant the option to plead guilty to theft, and then the prosecution will withdraw the robbery. This also has advantages on both sides. It gets rid of the case quickly. It spares the state the effort of recruiting a jury, going through the entire case, proving guilt beyond a reasonable doubt, which is the standard in criminal cases. There are incentives why the state might want to offer a plea. It gets rid of the case and still holds the defendant accountable for their actions. And of course, the benefit to the defendant is perhaps a lower sentence or a conviction for a lower level crime. There are reasons why the defendant might want to take that plea deal as well. There's also a special subset of cases where the state will often offer a plea, and that is in sexual assault and particularly child sexual assault cases. The reason why the state will offer a plea here is because if it goes to trial, under the Constitution, that child would have to testify in the case. It can be traumatic for the child to relive the experience, and because different people experience trauma differently, the jury might have trouble believing them. So someone who laughs nervously might not be believed by a jury when they're talking about how their parents sexually assaulted them. Or someone who's very blasé about it because they've now talked about it 500 times, so in front of this jury it doesn't feel like anything. So there are reasons why we would want to spare the child the anguish of testifying, and also not show the jury exactly how the person deals with trauma because they might not understand it. Just remember that a plea deal is a deal. So when you read in the news that somebody got a deal on their case, it may seem cushy, but that's the idea of a deal. The defendant has waived their constitutional right to have a trial, to cross-examine witnesses against them, to have the evidence heard, and to have the state, or the federal government, prove their guilt beyond a reasonable doubt. All of that is gone. That's not something, typically, that people are going to give up without getting something in return. So the state has the benefit of not having to go through all the time and energy of a trial, and the defendant has the benefit of getting off a little easier. That is the point of a deal. Well, that's all for this episode, and until next time, we're adjourned.